Hi everyone, my name is Aimi Ghazali and today I would like to discuss about the Falk and Federal Commissioner of the Taxation case. So here is the general overview of this presentation. First of all, I would like to talk about the background and the layout of this case. The material fact that relevant to this case. There is a few issues that arise from this case and the reasoning that judges use to make the decision which involve a few numbers of sections and cases. Then I will talk about the implication to the taxpayer and lastly the reference. So here is the background of this case. The case was held on the 4th June 2015 and appealed in the Sydney and it was in charge by the Justice Curtin. The case outlined the principle of the recoupment, indemnity, act of grace and the character of the payment to the payer and payee. The tribunal held that the cost of 500, 350 and 33 cents paid by the FCT government to the Michael Falk under a deed of settlement and release constitute an accessible recoupment. This finding was despite FCT government at all times referring the payment as an ex gratia and not constituting accessible income. The AAT comes at the end of the acrimonious litigation waged by the Falk against the FCT government and will not doubt raise the ire of the taxpayer. More concerning, however, in the adverse impact on the litigant who fail to understand when their settlement deed may invoke the application and fail to factor the cost of a tax liability into their settlement negotiation. The taxpayer, Dr. Falk, was a senior clinician at the Canberra Hospital operated by the FCT House under auspices by the FCT government. In May 2006, Dr. Falk was summarily dismissed in the hospital, whereupon he commences proceeding in the Australian Industrial Relations Commission seeking for the reinstatement. The proceedings were vigorously defended by the FCT House, causing Dr. Falk to incur significant legal costs. Dr. Falk claimed his legal costs as a deduction against his assessable income in the relevant income tax year over the course of the proceeding. In November 2007, the ARC ordered Dr. Falk be reinstated to his position at the hospital and delivered a judgment sketching of the hospital management team. In the light of ARC finding, Dr. Falk filed an application in the ARC within time for his costs. Thereafter, settlement negotiation ensued between parties on the issues of the Dr. Falk costs. At the end of May 2008, the ACT government on behalf of ACT Health agreed to pay Dr. Falk the amount of 500, 350 and 33 cents for his legal costs. The offer to pay was subject to two conditions, the first being that Dr. Falk withdraw his application for costs and the second that he provide a release to the government. The payment was determined by the FCT government to be an act of grace because there was no legal liability at the stage for FCT government to pay any cost to the Dr. Falk. Dr. Falk accepted the government's offer in September 2008 and disclosed the payment amount in his income tax return for the year ended 30 June 2009. The Commissioner assessed the payment as income subject to the tax and Dr. Falk objected. The issue arises when the tribunal need to determine the character of the payment, whether the payment received was a recoupment, and whether it is accessible. The accessibility was depending on the character of the payment, whether it was recognized as an indemnity or the act of grace. In order to rule in the case, Justice Curtin has reached the decision by the help of the various pieces of legislation and the case. Section 20 outlined the certain amount received as a recoupment of the loss or outgoing. It is accessible recoupment if you receive an amount by way insurance or indemnity and you can or have to deduct the amount to the loss or outgoing. Section 2035 states that recoupment include any kind of recoupment, reimbursement, refund, insurance, recovery and indemnity. The payment of legal costs can only be the act of gratia if there is no legal liability on behalf of the payment made. Next is the cases that involve to find the solution. First is the role and the Federal Commissioner of the Taxation. The FCT confirmed that is no general principle that an amount received as a compensation for or reimbursement of a deductible expense is accessible income. The payment to Dr. Falk will only be accessible if it fell within a particular category of the statutory income. Next, TAXA case states the definition of the term indemnity reaching to the indemnification in respect of losses that are already incurred in the context of the legal cause. Turning to the meaning of indemnity, the AAT referred to the bachelor case that defined the indemnity is a protection against hurt, damage, or loss, or compensation for loss or damage sustained, and found that the word indemnity was capable of encompassing past loss. The AAT looked at the payment made to the Dr. Falk, namely whether it was the character of indemnity or the act of grace. AAT said that if the payment is an act of grace, is not one apt to be regarded as the indemnification of the outgoing or any loss, and that is a payment was made for a reason, otherwise that account on the legal liability. The AAT said it was not inherently implausible that ACT government had paid Dr. Falk without having the least regard to the question of the territory's legal liability for costs. But Dr. Falk did not call evidence to prove the territory motivation for the payment. ATT concluded that the character of the payment was consistent with an indemnity for the government's legal liability to Dr. Falk, and that the ACT government reference to the payment being act of grace was only to comply with its internal procedure. Lastly, the implication for the practitioner, Dr. Falk, is that he needs to pay for the tax on the amount as the payment made to him was recognized as accessible with the tax term for the year it was incurred. It is important for the taxpayer to know the character of the relevant payment will be. Even if the payment references, for example, the grace of payment, it may not necessarily be. Therefore, this case confirms that care must be taken when framing a settlement offer and drafting accompanying deed that unintended or unfunded tax obligation do not arise. Thanks for watching, and this is the end of my presentation. Thank you.